Also breaking tonight for the Clinton campaign, a federal judge unhappy with her, demanding that the former Secretary of State and two of her most trusted aides go on the record under penalty of perjury for the first time about the private email server that she used as Secretary of State. Fox News senior judicial analyst Judge Anna Napolitano is here. So this is one of those Freedom of Information Act requests that was filed against the State Department that they blew off. They gave information and they were not truthful about every place they checked and the extent of the records, and this judge has about had it with all of them.
He has, and Friday afternoon he ordered that her two aides, whose faces were just on the screen.
Cheryl Mills and Huma Abedin.
Correct. As well as Mrs. Clinton herself, certify, quote, under penalty of perjury, a phrase rarely used by a federal judge, never, in my experience, used by a federal judge when dealing with a present or former federal official. Certify under penalty of perjury. What happened to these emails? How did they get from your computer as Secretary of State to where they are now? What circuitous route did they take?
And not just you, ma'am, but your two top aides, which is, that begs that we haven't seen anything from them yet.
Now remember, Mrs. Clinton is not in the courtroom and she doesn't have a lawyer in the courtroom. This is a lawsuit filed by Judicial Watch, a watchdog group in Washington, D.C., under the Freedom of Information Act against the State Department looking for her emails. The case was once dismissed because the judge bought the State Department's argument that we don't have
everything. We gave everything.
And then the State Department and Judicial Watch together came back to the judge saying, you got to reopen this case. We just learned that she's been hiding tens of thousands of emails from us.
So, but here, just to round back with the viewers, remember when this first came out that Hillary had her own email account and it wasn't on the StateDepartment.gov website and so on, or server. Marie Harf was asked, are you now going to go back and comply with your legal duties to pull Mrs. Clinton's records for all the Freedom of Information Act requests and all the congressional demands that you at State said you met?
Right.
And now we find out you didn't even bother to check Hillary Clinton's server and so on. And she said, no, we're not. We're not going to go back and look at any of it. And this was the prediction. You were on the show. We talked about it. You and I both agreed with this. This is what we said. She said they will not be going back and examining whether her emails were produced in response to FOIA requests, Freedom of Information, that have already come in. I have news for you, Marie. Yes, you will be doing that. Trust me. Once the lawyers get a hold of you, you're going to be doing it.
Well, that's exactly the situation that she's in now. Here's another fear Mrs. Clinton should have. When the government suspected that General Petraeus kept secure documents in a desk drawer in his house, in his home, the FBI raided his home to get those documents. The government doesn't suspect that Mrs. Clinton has secure documents. We know she does, and she gave a thumb drive to her lawyer, who does not have a security clearance.
So why the double standard? Why would they be so enthusiastic about raiding the home of General Petraeus and not a Secretary of State Hillary Clinton?
I suggest to you that we would have to ask that to Attorney General Lynch or even the President himself. Mrs. Clinton should be treated like anybody else who is apparently, I'll take that back, obviously violating the law by failing to secure classified documents and keeping them in insecure venues not approved by the government.
I just want to put it on the board so the viewers can see for themselves what this Judge Sullivan wrote. As related to the FOIA request, this is Freedom of Information request in this case, the government is hereby ordered to request that Mrs. Clinton, Mrs. Abedin, and Ms. Mills confirm under penalty of perjury that they have produced all responsive information that was or is in their possession as a result of their employment at the State Department.
Look at the date, July 31st. He gave them until August 7th. He just gave them a week to do it. And I cannot emphasize to you too much the significance of this federal judge appointed to the bench by her husband, using the phrase under penalty of perjury, reminding her, for the first time, Mrs. Clinton, you will be under oath. And if you deviate from your obligation to tell the truth, I will know about it, and you will bear the consequences.
She was not, as she was supposed to be, required to fill out that OF 109 when she left State.
We've been through that.
She should have been required to do it, but of course they gave her a pass. This judge has basically said, you'll do it now. You'll certify under a penalty of perjury that you have given all the documents you had, and if not, there will be a consequence.
And if the FBI doesn't get the server, and Congressman Gowdy's committee lacks the authority to get the server, guess what this judge can do? Order the server produced into his courtroom and examined by experts right then and there.
That's amazing. I mean, they are not officially parties to the lawsuit. The judge didn't directly order these 3 women to make the certification. They're ordering the State Department to go get them. But that puts State and Mrs. Clinton in a very difficult position.
It does.
Great to see you, Judge.
Likewise.